Okay, here's what you need to remember. There are two types of custodies, or two types of jail rather, and just two types. There is no third type. When you're arrested, you're first taken to the police station. Wherever you're arrested in India, you're first taken to the police station that has effected the arrest. When you are in the custody of this particular police station, you are supposed to be in police custody. Almost all the police stations have sort of a confinement which looks like a jail. It does not look like the jails that you've seen in movies. It's dirtier than that. But yes, you know it's a jail. You are here for the purpose of interrogation. You've been arrested for a particular reason. Now the cops want to interrogate you to find out what exactly transpired, what was your role, so on and so forth. This is called police custody. In short, when you are inside the police station in that confinement, it is called police custody. Police is not supposed to have your custody forever. In the sense, they cannot keep you there for months on end or weeks on end. How long you can be kept in this particular police custody is determined by a judge. As soon as you're arrested, within 24 hours you'll be produced in front of a magistrate who will determine first and foremost whether your custody is essential, and if so, for how long will you be kept in police custody. Usually it's 2 days, depending on the gravity of offence, or it can be 4 days, it can be 5 days. At the end of this time period, you're again produced in front of the magistrate, and usually you are sent out from police custody, not into the real world, but into what is called judicial custody. In some places it is called magistrate custody. Now this is jail. This jail is separate from the one which you were held in, and the police officer does not have any powers in this jail. This is actual jail. It is called central jail. It goes by various nomenclatures, but is very clearly distinguishable from the jail inside police station. What is the difference? The difference is in judicial custody, the police officer cannot interrogate you the way he could have in his custody. You are basically an under trial now. You are in judicial custody, you cannot be interrogated by police. You will now have to apply for a regular bail. I know all of this is information overload for you, but believe me, if you are watching us, by the 10th episode, you will be able to understand all of this very, very well. And this is why I have been telling you, stop reading sun signs alone. Come watch us, we are free. In a matter of few episodes, you will know some of your rights that you need to know. You will not scare and shiver and freeze when you are confronted with an arrest. I am now going to read out a very, very, very important aspect of law in India. Procedures to be followed upon the arrest of a person. These procedures or guidelines have been laid down by the Supreme Court of India in a very, very famous case called D.K. Basu versus State of Bengal. For those of you interested, you can write down D.K. Basu versus State of West Bengal 1997. In this particular case, the Supreme Court has given guidelines which are now mandatory on all police officers across the country to adhere to certain guidelines when and after making an arrest. I am going to walk you through these guidelines, and there are 10 of these, and you will at the end of this know your rights or that of a prisoner. I hope you will never go to a jail, but if you are going to go to a jail, these 10 guidelines will stand in good stead to prevent any police officer from violating some basic rights. I am going to read out the guidelines now. Read out and explain also. Well, this is what Supreme Court said. It is therefore appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in that behalf as preventive measures. And I'll tell you shortly whether these measures have been modified or rescinded or whatever, but as of now they're effective. Point number 1, the police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible and clear identification and name tags with their designations. The particulars of all such police personnel who handle interrogation of the arrestee must be recorded in a register. To make it simple in English, plain English, anybody coming to arrest you must clearly state who he is, what his designation is, and this must be clearly demonstrated at the time of arrest. Maybe the reason is that if somebody just walks up and is in a fancy dress of a police officer and not a real police officer, he can cause you harm. Probably you're getting kidnapped instead of getting arrested. So a police officer must not feel offended if you want to see his name, designation and some sort of an official identification. Point number 2, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness. This witness can be a family member of your family or a known person from the locality. And so also, it has to be countersigned by the arrestee and will confirm the time and date of arrest. So the second point says that he cannot just come and hold you by your palm and say, I am arresting you, come with me. If he does that, I'll tell you in the end what you can do. Remember, he has to have his name, designation, everything prominently displayed. You can ask for an ID, and he must give you a memo of arrest, a document of arrest, which records the time of arrest, the date of arrest, and this memo of arrest must be signed by a known person from your locality or a member of your family. I am not sure how practical this is, but it certainly is practical that you must be given some proof of your arrest. Remember, law is common sense codified. So if there is an act which defies common sense, it probably is not law. Somebody needs to be informed that you are arrested. You're not kidnapped, you're arrested. So, third point says that somebody who's interested in you, this could be a family member, usually a spouse, or a parent, or a sibling, or a friend, must have information that you are now arrested. The person who signed memo of your arrest, remember in point number 2 we said that somebody needs to sign. If that person has signed and has been made aware of your arrest, that's good enough. But remember that you cannot be arrested with no information to anybody known to you. So, in India, if you are arrested, it is the duty of the police officer to inform somebody from your family of your arrest. If he is not doing so, you can insist upon him to do so. You can actually tell him, ask him, has he informed somebody in your family of your arrest, and perhaps you can notify a name and number for this police officer to intimate about your arrest. I will now come to point number 4. Wherever your friend or your relative is outside the jurisdiction of this particular police station where you are being held, in such cases the time, the place of arrest and the date must be communicated by this police station to the local police station wherever your relative is staying. And there is also a provision that it can be done through a legal aid organization in the district and the police station of the area concerned telegraphically within a period of 8 to 12 hours. So within 8 to 12 hours of your arrest, this police officer must convey to your relative, wherever that relative stays, about your arrest.